So I want to start with our first panel. If you remember the advertisements, we had Andrei Iancu and Judge Randall Rader. Turns out Judge Rader has a class this morning in China. So he's not going to make it. So we worked and we found the right replacements that actually can drive this discussion. So if I can get everybody to come up, I'll make the quick introductions as you're coming up. So I don't think Andrei needs any introductions. From the USPTO to head of IRL to, are you in charge of Sullivan and Cromwell by now? Patent litigation, patent prosecution, he's seen it all. Terry Rea, former deputy director of the USPTO, a decade plus at Crowell and Mooring. Now in her retirement, so she said, I get to be my own boss, and does a lot of expert witnessing work. And then, judging by the name tag, one of our great late additions, Steve Akerley. So Steve, if you don't know Steve, really is one of the most knowledgeable U.S. lawyers on international litigation, because he's the head of litigation for InterDigital, one of the great research companies. So we have this great group, and I am a little bit humbled to try to moderate this group, not to mention I know how vocal they all are. So with that, let me shift over. So I guess I wanted to start with the question, or with the point maybe, that the UPC still remains a mystery to huge sectors of the U.S. IP industry. My impression is the life sciences lawyers are probably more knowledgeable, but when you talk to the tech lawyers, they moderately aware of the UPC, or maybe they're not aware of it at all, but they just lie to me, so they don't look like they don't know. So I would love to just start with that initial question. Why does the UPC matter to American companies, American innovators? So, Steve, I'll start with you. You're closest.
You put me closest. Okay. Well, it matters for a number of reasons. One is it is a new judicial body that has jurisdiction and authority throughout the EU. It has the benefit of injunctive relief throughout either the member states or where you may have validated a non-unitary patent in each of those countries. So there are these benefits to it. Also, the approach that we have seen so far indicates that it shouldn't be a mystery, right? The UPC so far in its 2 years, a little bit over 2 years of existence, has applied basically EU regulations and laws, much like some of the national courts, following CJEU, that's the Court of Justice for the European Union, precedent and authority. And so to not know about it suggests to me a fundamental lack of awareness that really shouldn't exist if you do this for a living.
I want to seize on something very quickly to make sure this principle gets out there. You mentioned injunctive relief. I remember a time in the United States when tech companies could get injunctive relief. I think I had hair. You want to just briefly mention what that's about?
Well, sure. Like national courts in the EU, German courts are famous for this because for a variety of reasons, that's where a lot of companies file patent infringement cases. The principle of issuing an injunction after a successful infringement case is I don't want to say it's automatic, because nothing is automatic, but these courts, and the UPC is doing this so far, has retained these, what I consider first principles of patent law, which is the right to exclude. That is completely lost in the United States at this point. I say completely, I don't know what the percentages are, but it's extremely low percentage of cases where permanent injunctions are issued in patent cases in the United States. don't even talk about preliminary injunctions. They effectively don't exist. And so that's an important factor.
Could you expand on the phrase where you have validated a non-unitary patent? What exactly does that mean?
Repeat the question. Oh, the question was, what did I mean when I said
Where you have validated a non-unitary patent?
where you've validated on? So if you have an EPO patent, right, you can select jurisdictions where you file, right? And in the patent game, we call that validating in those specific countries. So in the UPC, say I have, if I'm using a non-unitary patent, that is, I've either opted that patent in, it existed before the UPC, I opted it into the UPC, or I opted it out when the UPC went live and withdrew that. There's a grace period where if you've opted patents out, you can then withdraw that opt-out and use that patent in the UPC. The extent of the injunction that will issue is not all member states in that circumstance. The extent of the injunction, at least as portrayed, there is some question about what might happen if it's an EU defendant, but the injunction will issue in the member states where that company has sought and paid for patent protection for that earlier issued patent. So if you had only validated in Germany, France, and if Spain wouldn't work, but Portugal, when you get an injunction at the UPC, the injunction will apply in those states where you have validated. Not all, I'm not up to speed on how many states have validated now, whether it's 17, what have you, but it won't be that, you won't get the injunction for all member states. You'll get the injunction only where you have validated.
And we'll have several panels going through that. I did appreciate the head nods from the European lawyers, so you got it all right so far, Steve. So, well, Andrei, in your view, again, why do U.S. lawyers need to be paying attention, and maybe with some emphasis on small, medium enterprises?
Yeah, well, thanks, Wayne, and great to be with everybody. Again, lots of familiar faces here, and great to see everyone. So the rise of the UPC and the way it's enforcing patents both substantively and procedurally, and we're going to talk about all those mechanics throughout the day, but the rise of the UPC is corresponding to an enforcement environment in the United States that has been weakening. So, as Steve mentioned, for example, it's very difficult to get injunctions in the United States. This is the case for the past 20 years since the eBay decision, although it's gotten progressively more and more difficult with every new decision from the lower courts. So that's one example. Not having access to injunctive relief is a critical issue for being able to effectively enforce your patent, obviously. It's gotten more expensive to enforce patents in the United States with added procedures, lengthier cases, lengthier time to trial, the activities at the PTAB with the additional validity challenges and the like. And the environment on appeal, even if you do win below, is also difficult, with the Court of Appeals rarely affirming large judgments. So if you are a patent owner, an inventor that needs to enforce patents against competitors, or just folks who are infringing on your patent, and you have the choice of jurisdiction. Okay, not everybody has the choice of jurisdiction, but if you have the choice of jurisdiction, you might look elsewhere where the enforcement environment is friendlier. And this is why it's you see more and more patent owners voting with their feet and choosing to enforce at the UPC and some other places around the world. Germany is an example. Brazil had been an example for a few years. Even Colombia, in some circumstances, they're choosing a different jurisdiction that provides more immediate and practical enforcement mechanisms. And the bottom line is, if you're an American lawyer with clients that have worldwide portfolios, and face worldwide infringement, you absolutely need to be familiar with all these other jurisdictions, because that, it might be more beneficial for your client to enforce elsewhere. We have to come back to all of these points, Wayne, and delve a little bit deeper. But this long term, has and will have, already has had and will have a deep impact on the American innovation economy, because the enforcement environment goes hand in hand with the original innovation environment. But that's a longer discussion we can return to in a minute.
So I think one of the phrases that always catches my attention is it's faster, radically cheaper, and a whole lot more frightening with that injunction than the U.S. system is right now. So there's a lot to be learned from the system, in addition to being, I guess, it's a model for what we may need to look at as reform on things like litigation cost. But Terry, you come from a different technology stack than the rest of us. I started off by saying tech lawyers are behind, which necessarily means life sciences lawyers.
Necessarily. But
Well, I'm going to go with most life sciences lawyers are ahead of the tech lawyers on this discussion about the UPC and global markets.
yeah.
What's your feel on the UPC and what it means to innovation here in the U.S. on the life sciences side?
So I think that this is very timely to have this seminar, just so we learn what we don't yet know. And it is rather complex for us American lawyers, so we're not going to absorb it all today. But this should be a very, very helpful discussion. So I was in the PTO from 2011 to 2013, and that was just when the UPC was a glimmer in everyone's eyes. So the EPO Board of Appeals judges were the ones that were looking a whole lot, seeing what they did right, what they wanted to bring over to the UPC. We had a lot of those people come to the USPTO and find out, what are we doing with the PTAB? Because the PTAB was just being created right then. And one thing that the PTAB was very hard and certain with was timing, for instance, minimal discovery, and a lot of that did remain with the UPC. But from the life science perspective, historically, the most international litigation I've done, it was in London, because that's where most life science litigation was. And then after I left the PTO, we had Brexit, and then it was a little bit disheartening to find out that that pan-European injunction wasn't going to be as big as we had originally thought. But I understand that now more life science companies are in Paris for the most part. But Munich gets most of the cases, of course, and people always thought that would be the case, and it continues to be. But from the life science perspective, health and well-being is not an solely American issue, right? And disease states and conditions are perhaps just as prominent in other countries throughout the world. So even when I was a patent prosecutor way back when, I filed in just about every country of the world, even countries that didn't have great legal systems. But the UPC, I think, is people in the life science sector, some of them are now thinking about starting in the UPC, not starting in a U.S. district court. And it breaks my heart when that happens, frankly. But they're starting in Europe now, and they can try and get that injunction. And if they're successful, then they think that, well, maybe they'll have a better chance if and when the need arises to litigate in the U.S. So it is sort of interesting just watching the life science community. But I always preferred London. London was where I was the most comfortable. So I can't stay for the entire day's discussion, but I am eager to find out what's the likelihood that the UK will ever possibly be able to join the UPC.
We have the people that can answer that question. Steve, maybe from your perspective, I mean, InterDigital is this great research company, often compared to like universities in terms of what it's turning out.
Yeah.
How is it viewing protection globally and in light of the UPC change? What were you looking for in a patent portfolio going forward, kind of thinking about the next decade?
Yeah. Well, even before I took the job at InterDigital, which was 5 years ago, I was in private practice doing patent litigation. In the last 5 years, at least, of my private practice, I was looking for portfolios. If I was looking at, to help someone monetize, I was looking at portfolios that were, if they had a big U.S. component, that was fine. But what we were really looking for, and I think firms are still looking for, is a significant European component and elsewhere, right? Whether that's portions of that in Brazil or other countries. But if you think about it, all of that preference is in some ways due to speed and cost, but I think it fundamentally all comes back down to the ability to obtain injunctive relief in a given forum. And what we've seen in the U.S., obviously, we've already talked about that erosion, but that's happening now in the U.K. as well, at least in standard essential patent cases, where the UK courts seem to be desiring to enforce interim licenses or to take on global rate setting cases, to set rates globally, and are there eroding the ability to get an injunction in the UK as well. And so when I think when anybody looks at a portfolio these days, you have to look at the makeup and see if there are adequate assets where to protect your technology in jurisdictions where injunctive relief is available.
So for those of you who don't know me, I litigated for most of my career and then got an opportunity to work under Andrei at the USPTO. I stepped out of big law because I heard one of his presentations, and for better or worse, it impressed me that you were talking about this idea of small, medium enterprises being able to participate in the IP system. Just kind of from the very beginning, that it's, the big companies will find their way. Maybe everyone else needs a little bit of a boost. InterDigital, I consider one of the giants in the IP space. Can you kind of relate these to that small, medium enterprise where they can get involved, and what do they need to be thinking about in terms of a 10-year plan?
Yeah, sure. So, Elon Musk famously said that patents are for the weak. He meant that pejoratively, right? And I don't think he realizes that he's actually right. The reality is that patent protection is first and foremost for the inventor, for the investor in that in the innovation, for the garage entrepreneur, for the research and development companies, the small and growing entities that need something to take on the big established companies. No matter how brilliant your technology is, once it's out in the public domain, it is virtually impossible to break through the market penetration of the established firms without the protection of the rule of law. One way to think about it is, if you have a battle between David and Goliath, okay, David needs his slingshot. Goliath does not need a slingshot. Goliath hates slingshots. Goliath wants to make slingshots illegal. But David cannot take him on without something. And our founders in the United States in the 18th century saw that for effectively a startup nation, if we wanted to penetrate, and if we do want to penetrate, and you need the protection of the rule of law. So a country with a free market system, if you want to grow technologically and be a powerhouse innovation economy, you need an intellectual property system. I think, by and large, this is accepted. I think in most circles in the free world. But if you don't have an enforceable mechanism for that intellectual property system, it's as if you do not have an intellectual property system. To have a patent or a trademark or copyright, whatever it is, to have it and get it is meaningless by and large if you cannot enforce it ultimately. And not just enforce it, but meaningfully enforce it. Not to take 10 years or 15 years and spend $20 million that very few people can do. And at the end of the day, maybe potentially get some money for that you should have gotten 10, 15 years ago. That's not a meaningfully enforceable intellectual property system. And without it, the reduction in principle is basically to where we were without an intellectual property system. And all of these issues are accentuated for the startups, for the small companies, for the medium companies, for anyone, for entrepreneurs, and for inventors and their investors who need to take on the established firms and break through with the disruptive technologies. It's accentuated for them, just like it is for David in his fight against Goliath, because there's no other mechanism. There's no market power that they have to be able to penetrate. There's no size and all of those other tools that the big established companies already have. And what's really important to realize and to understand is that disruptive innovation happens on the edges. Disruptive innovation at scale happens at the entrepreneurial level, at the startup level. Of course, the big established firms also innovate, no question. But the disruption, time and time again, is in the startups. Apple was once a startup. Google was once a startup. The big pharma companies were once a startup, and they often acquire startups, even nowadays. And for those, our founders knew early on they need exclusive rights. Without exclusive rights, it's very difficult. So now, what do? Right? If you don't have that mechanism here at home in the United States, if you have the ability, you have to look elsewhere. And that's where the UPC comes in. But what's obvious here is, for that to work, number one, you have to have a global portfolio. You have to have rights in Europe if you're going to use the UPC. Not everybody has that, or the resources to have that. And you have to have a market over there as well. It's not always the case. Sometimes for telecom, like what InterDigital does, for the pharmas, obviously, almost all the time, perhaps there is both a US and a European and an international market. But not all innovations like that. Especially at the beginning. The disruptive innovation usually starts at home. So, it's not, a tool for everybody. But given the environment at home, I think more and more inventors and patent lawyers are beginning to look at expanding those portfolios specifically to take advantage of this new resource.
So, Steve Carlson, I'm going to put you on the spot. So, Steve, one of the original innovators for this conference brought this to my attention years ago. But I know you've been doing a lot of joint proposals, just in a rough magnitude. We'll talk about it in more detail, what's the difference in cost from filing to resolution and from the U.S. to a UPC action?
It's absolutely embarrassing. I mean, it's roughly 10% of the cost to go litigate in UPC.
So let me make sure that number hits the microphone. That the UPC from beginning to end through resolution is 10% of the cost of a U.S. litigation. That takes how much difference in time?
Oh, again, it's UPC, you've got your trial in about a year, maybe a little bit more than a year. With US, quick is still get through 2 years.
But really, you're looking at 3 or 4 years really in the U.S. system if you factor in a PTAB challenge. So it's the bang for the IP buck is very clearly in Europe and not in the U.S.
So this idea it's 10% cheaper, it's got an injunction, and it's fast enough to actually be in the innovation cycle. And I think that's something that people don't discuss enough, especially in the high-tech space.
To be clear, I think he said it's 90% cheaper.
Oh, sorry, 10% of the cost, 90% cheaper. Yeah, big difference. 90% cheaper and considerably faster to be in that cycle.
Would you please address a little bit about 101 environment there and discrimination against the NPE? I think when you say 90% reduction, it means there is no discovery.
Well,
Steve, you've been
certainly that's one of the big. I was going to say that if it's not known to people, the U.S. is unique in that we have full discovery, and I say that if you've been through it, you know what I mean. But I mean, you send out document requests, you get depositions, and you get sometimes millions of pages, right? In a big case, discovery doesn't exist. In any other jurisdiction I've had cases in, which is a fair number now, there are disclosures, right? There are some disclosures. The UK has more disclosure requirements, for instance, than a German case or a UPC case, but enormously reduced. So that is part of the increased cost in US cases. I will say UK SEP FRAND rate setting cases are extremely expensive because of the complexity involved a lot of that time and the different approach in the UPC, at least to date, in some of the national courts like Germany have even, like I said, fewer disclosure requirements. So that certainly adds to the cost. The one thing that I wanted to say, picking up on something that Andrei mentioned, the other issue is finality. In my experience, and I think this is right, we'll see if the European lawyers nod their heads again, the courts of appeal will rarely remand cases back to the court of first instance for a retrial or a discussion or a new decision on a particular issue. They typically affirm, reject the appeal, or will render their own decision, right? And so, and that has been the case in my experience at the first Court of Appeal, and then, for instance, in the UK Supreme Court, the same thing. So, in the US, by contrast, the Federal Circuit and other, if you take it out of the patent context, I think it's largely the same. Many times, the courts of appeal will remand back for a full trial. Sometimes it's partial, sometimes it's just on damages, but that's a significant part of any patent case. And sometimes it's a full retrial. That leads to sometimes more than a decade of cases going up and back between district courts and the Court of Appeal in the U.S. And so, again, just a distinction in how the courts of appeal in foreign jurisdictions handle those appeals and what the result is then. Terry?
So I thought your question was good in terms of discovery, because I personally worry about SMEs. Do they have access to sufficient information to even be involved in a case at the UPC? And I realize that in the US, we oftentimes overdo discovery and the cost is tremendous, and we seem to have this basic inability to rein it in. How would we rein it in? I don't know. People have tried many times, but I do worry that your complaint or whatever is filed at the UPC, you're sort of stuck with the allegations there. And that if you become aware even of information during the course of the case, during that year, you may not be able to bring the issue before the court. It might not be alive. And so I do have concern that they don't have the benefit of, and I don't want to say robust discovery, but some limited discovery more than what you see now. It's only been in action for 2 years, so it remains to be seen. I'm sure that just like the PTAB was modified every 2 to 3 years, right? I think the UPC will shift a little bit, and one court will try something, and then another court will say, oh, that was a good idea, so we'll do it, so they could play off of each other. But in terms of SMEs, I do worry that a little bit of discovery may benefit them.
Steve, you've been there. So what
Well,
do you think? Let me say this: it's extremely uncomfortable if you've only been in U.S. litigation and then you have to go overseas and do it. By the way, whether you're the patent owner or the defendant, it's frightening to lose that. It's like a warm blanket, right? Discovery in the U.S. You can never get enough of it.
A very expensive warm
A very
blanket.
expensive warm blanket. So I have found that it takes maybe a little bit more work at the front end to make sure that you have the information that you need, and again on both sides as you go through a case. But we haven't experienced. I haven't experienced personally, having done those cases even before I was at Interdigital. I haven't experienced a circumstance where I felt that we didn't have enough information. It is possible, of course, that a smaller entity might not have access to some of that information, but I think in general, in this day and age, that's probably minimized at this point.
I will say that it's also going to be different between technologies.
Oh, absolutely.
So,
Absolutely.
if you have a case on standard essential technologies, you have automatic access to the standard and so on. So it's a bit different than if you're dealing with proprietary formulas and formulations in pharma cases and the like. But either way, I generally agree that there is, they're on the sufficient side of information over there in Europe. They could do better, no question. And I do agree with Terry Rea that they will improve, I think, in time. But I don't think the goal for them, not that I'm in a position to advise the UPC, but I don't think the goal for them should be to adopt the warm blanket that we have here in the United States.
Certainly hope
it's a little bit too warm for some SMEs.
So, Mark,
Yes, a few words regarding the cost. I just want also to mention that compared to the US system, you have no deposition and it's only a one-day trial hearing. So it means that basically you're just going to be in a trial lawyer position where you're going to have your as a UPC representative, you're only going to get your prior art and you're not going to discuss it directly with the judge, which means that you spend way less time preparing for deposition. You don't record anything. I mean, the hearing is recorded, but I think this is a really cost-effective way of dealing with this issue. On the other side, about what you mentioned regarding the access to evidence, and from a trial lawyer point of view, I think we kind of have the same thing in a way that you're still going to discuss, you're still going to tell your story to people. That's what we do, The only thing which really, really changed is the way you're going to do that. You can have access to a lot of information, but it's actually going to be extremely different from what you have in the US because you're not going to have discovery, but you're going to have order to preserve evidence, and then you can obtain some really specific documentation. Because what the judges have in mind in Europe is the effective access to justice. Because when you are talking about SME, a SME in the US will be huge for an SME in France, the Netherlands, or Germany. So I think that even though I completely understand the concern and I can share some of it, at the end of the day, you manage to get what you want.
So Ari, I think you can take the mic here. Thank you.
Yes, thank you. I had a question, actually two questions for the panel, if I may. They're linked. Because you were saying a moment ago that in the US, you just don't get injunctions nowadays. But it's been the orthodox view for some time that if you're going to get to the ultimate resolution of a dispute, you need a US case, because that's got enough punch to break through and cause a settlement of the parties, but it does it without an injunction. So my first question is, how is that possible? Because there's no injunctive relief. So what's the thing that makes things settle after a US trial? The second question is, you do get an injunction in the UPC. Do you think it'll actually work in the same way that the US gets there without an injunction? Is the UPC injunction powerful enough to have that punch to make the settlement happen?
Yeah, happy to start. Great questions. First of all, about the United States, let me just say that just to clarify the record here, there are still injunctions entered in the United States in some cases. It's not a universal blanket rejection of injunctions. So, specifically, if you have a direct competitor-to-competitor case, and you go through the factors and the public interest and all of that, there are situations where injunctions are entered. There are situations where preliminary injunctions are entered. So it's not universal. But the bottom line is it is significantly more difficult in a large number of cases, especially when you're not in a competitive position, then you don't get injunctions. So what makes a case settle in the United States? Look, the one thing you do still get in the United States that it's more difficult anywhere else in the world is significant damages. Number one, the market is very large for many patented technologies in the United States. It's a unified, large consumer market, number one. Number two, the prices are usually, depending on the case, but usually the prices per unit are usually higher than in most of the rest of the world. And juries, because these are jury issues in the United States on top of everything else, are much more inclined than courts elsewhere around the world to give fair value to those to that large infringement. Whether that stands up or not on appeal, it's a different issue. Lately it's had a tough time for large judgments have had a tough time, but the threat of a large verdict combined with potentially enhanced damages for willful infringement is a concern to many defendants, and together with the litigation costs over the same number of years, 4 or 5 years, however long it takes, that does sometimes drive a settlement. But you're absolutely right. The reality is it takes longer than before when we had injunctions routinely, but it's still there. At the UPC, once you get an injunction there, obviously an injunction has teeth, but, it's not like it's an automatic settlement all of a sudden. Large companies in particular can just, pull the feature out, stop selling in the particular countries where the injunction is effective for a while. It's not like you have, a settlement the day after every single time. But these are all pressure points, large judgments in the United States, injunction in Europe, and maybe elsewhere. Those are pressure points to return to the patent owner the correct value and to make the accused infringer realize that they should take a license or reach a settlement. Neither one is a perfect and complete solution. And that's why a lot of patent owners, and I think Steve here can speak to this more directly, that's why there's usually a worldwide or a multi-jurisdictional effort to be able to touch on all these different pressure points.
The second part of that question is really good about if you get an injunction out of the UPC or a German court, does it get you what you want? Does it lead to a settlement? No, is the answer. I mean, it depends. It depends on the market. It depends on the scope of the injunction. It depends perhaps on the feature, right? It depends on the exposure in that location, in that jurisdiction. But there is the present mantra of implementers in Europe, because it's already here in the U.S., is and let's do this in the context of an SEP case, standard essential patent case, if an injunction issues, the implementer will automatically have to sign up for suprafran rates, right, that the patent owner shouldn't be entitled to. Well, empirically, you could go back and just look at the last 5 years and track. It wouldn't be the UPC cases, but it could be at the end of that. But look at the cases where around the world where injunctions have issued. They didn't force the implementer to take licenses at all in some circumstances. DivX has an injunction against Netflix in Brazil that I think precludes Netflix from providing HEVC video streams to Brazil. I don't believe that they've settled that case. If they did, I'm not aware of it, and it took a long, long time. There are lots of others out there, and you could. So it is, when I look at it, because I've been talking about injunctions, you might say, well, why are you all wrapped up on injunctions and the need for them? It's because that's what the patent right is, right? Bottom line. It's not, otherwise it becomes a compulsory licensing regime, right? And to me, it's not that silver bullet or the thing that causes somebody to have to pay suprafran rates. It's a victory. It upholds the patent. I get an injunction. If you can design around that patent, fine. Go ahead and do that. If you have to remove the feature, then you have to remove the feature. But it is not it's viewed as something that if it occurs, then the whole system will break down because you'll have people paying, like I said, suprafran rates. And it just hasn't. That's the myth of the injunction from the implementer's viewpoint, in my view.
But just ask the question, how big do you have to be? How much money do you have to generate every year to litigate both in the Europe and the U.S.? That precludes companies that are under, 100 million in revenue. It's tremendous cost. And I did heard from one litigation funder that said they really weren't interested in any case that wasn't in about the $70 million damages range. That cuts out a huge portion of the U.S. innovation economy. I mean, that's an enormous company. And if you've got to do both continents or maybe 3 continents, you've got to be looking for billions in damages. And that's kind of the part of the disturbing piece. Some people don't have the option to do Europe and the U.S. They don't have the option to do the U.S., so they have to look at markets like Brazil or the UPC to gain any leverage at all. As using Andrei's analogy, the slingshot is smaller than you would like, but it's all you've got. So, but one thing about the injunctions, Terry, your world is different. The place where injunctions are I think still more feared is in the life sciences space.
Yeah, so, we have that Hatch-Waxman paradigm where you get that automatic 30-month stay where the FDA can't approve another product like yours. But it's amazing the number of what we call them generic pharmaceutical companies here that launch at risk. And I'm involved in some of those, as a consultant, and it is, I'm not sure the right word is fascinating to watch, but it is fascinating. And it's fascinating to go to court and just to watch the faces of both sides. It's an interesting, we're jealous that you can get injunctions, put it that way, that the Europeans can get injunctions. What's the full value of the injunction? I don't know. But I can also tell you that in the U.S., when Andrei mentioned enhanced damages, it's treble damages. It's triple whatever you thought you were going in, and it is a huge amount of money, so the motivation to settle is still very much there. but every case is different, and the UPC is growing, and who knows where it's going to go in the future. Hopefully it'll get better, and the U.S. system will somehow get better.
So I'm going to give everybody one final say. Terry, you'll get to close us out. Just the question is, what do U.S. companies need to be thinking about, and what do U.S. lawyers advising U.S. innovators need to be learning to understand kind of the new paradigms for IP protection? So, Steve?
Just break out of the U.S.-centric mindset. I was relaying a story to Wayne at the beginning. In a case I've got, a firm on the other side is a firm that I worked for, and I relayed once they appeared in the case to my management that it was a great thing. They were great lawyers and good people, and I would always rather have that combination on the other side than a bad lawyer and not a good person. They have not done that well in the particular case because they, it seems to me, have not looked beyond what they have done for 20 or more years, right? They're looking at these things as U.S.-centric cases, and it's a big world, and there are other options out there.
Andrei?
Yeah. So two points at the policy level. First of all, you really cannot have a patent system without the right to exclude. The Constitution says that the patent and copyright system must give exclusive rights, and it's really difficult to understand how you have any type of a property right, whether intellectual property or real property or personal property, without the right to exclude. It's fundamental. And not having it, in many cases in the United States, is distorting the system. And it's creating all these issues where a lot of people are looking, American inventors are looking elsewhere, like the UPC and as we've discussed. However, at the same time, I don't think anybody here should give up on the U.S. system. Number one, you can't. It's a really important market. And for us here in the United States, it is our home market. We have to fight for our home market and make sure it works and it is efficient, and we continue to be innovation leaders around the world. And when it comes to injunctive relief, there is hope on the horizon that the system will be set on the right path. First of all, there is a bill in Congress. It's bipartisan, bicameral. It's been reintroduced in this Congress. It's called the Restore Act, and it would provide access to an equitable, exclusive right. Again, it's equitable. And it's not automatic, as it shouldn't be, since it's an equitable remedy. So that bill is pending, and Congress may take action in the near future. And the administration has said recently in a filing in a court in Texas, in the Radian case, that from the administration's point of view, injunctive relief is important for patents. So between Congress and this administration's perspective, we may be on a path of change when it comes to injunctive relief here as well. So we should keep an eye on it.
So Terry, final word.
So I'm as optimistic as Andrei is that the U.S. system will continue to improve. I do think that the right to exclude, I teach law school, and I say the right to exclude, and I think, but not really, asterisk, right? And so it makes it sort of complex. But I do think that the U.S. system hopefully will continue to evolve in a positive way. But my recommendation, I just left big law at the end of 2023. I would recommend to every law firm, irrespective of its size, to affiliate or develop a relationship with at least 2 European patent firms that are very talented and are good with the UPC. So you've got 2 different perspectives because you have a vast geography. It's not one country when you look at Europe, right? And that you should be affiliating, and when you think of U.S. litigation, you should automatically consider UPC, whether or not you act on it, but at least you should preliminarily have initial discussions and identify how relevant it is, either for the current time or for later on.
Wonderful. Well, I want to thank all three of you for starting us off. And for our next sessions, you'll notice a distinct change in accents as we bring you a group from around the world. And I'm not talking about my leftover Texas accent. So